every part of the information which is in its possession and custody. Don't wait for an order of the court. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India.
Political party doesn't need bond number. If a political party comes and says, I have received so much from so and so.
Salve, we take it you're not arguing a case for a political party, right?
No. On the contrary, I'm saying the reverse. I'm so sorry, I'm saying the reverse.
No, you have to disclose all details. Let there be no, because the burden should not lie upon the court or the petitioners to say, but this one has not been disclosed. But now this has not been disclosed.
Now we'll disclose it, but whatever.
We must have finality to it.
Yes, we'll do it.
5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop. SBI's attitude appears to be, you tell us to disclose a particular detail and we'll disclose it. That's not fair process.
But how we understood
SBI, this is the judgment of the Supreme Court. As chairman of the State Bank of India, I am duty bound to comply with the judgment. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, State Bank of India has the best legal advice open to it.
May I not take your lordships to the three orders, so how we understood them? My lord, your lordship's first order was 12th April 2019.
Sure.
And we have, for convenience, my lord, we have put the three orders together. Your lordships just see that. We'll give everything, there's no question. Just to explain that it's not that the impression which is being created, my lord, is that State Bank of India has been playing ducks and drakes with the court. I just wanted to clear that up. If your lordship sees the 12th April 2019 order in paragraph 16, but I had asked my friend to make a little compilation of the orders so we could show them easily. Your lordship has not.
Yes, para 17, right?
Para 16, my lord.
16. You got this?
Yes.
Yes.
This is the interim order my lords had been pleased to make. After my lord noting all the changes, the court would have to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same ensures adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require.
All right. Can we just see para 15 again, one?
Yes. The court therefore has to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same would ensure adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donation through the electoral bonds to submit to the Election Commission of India and seal cover detailed particulars of the donors against each bond, the amount of each such bond, and the full particulars of the credit received against each such bond, namely the particulars of the bank account to which the amount had been credited and the date of each such credit. So, my lord, your lordships felt this would ensure transparency, that you give all this, but you keep it in a sealed cover. So, my lord, a political party doesn't need bond number. If a political party comes and says, I have received so much from so and so, that gives the requisite details.
We take it you're not arguing a case for a political party, right?
No. On the contrary, I'm saying the reverse. I'm so sorry, I'm saying the reverse.
In the data on purchase and redemption of electoral bonds, in what format do you store it?
In two silos. Your lordship noticed that in the next order. So the data is maintained in two silos.
You store it in three silos. From your application, it emerges now that you do it in three silos. The first silo is the bond number.
Bond number is only on the bond.
And the third is the redemption.
My lord, bond number is only on the bond, and it is cannot be read except through under a UV light. That was only done, my lord, like authentication, like because it was a bearer bond. That's what was sought to
What's the
be issued.
purpose of the alpha? And second question, what is the purpose of the alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature, or is
The
it
security feature entirely.
in the audit trail? Do you also
No, my lord, audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question,
Yes.
how does the redeeming branch
Yes. Yes.
match the electoral bond number to determine that it is not a forged bond?
So they were not. That's what I'm saying. When they received it, the person encashing it gets it. He sees that it's a valid bond because you see the security feature. You don't keep a record of it. The physical inspection.
While redeeming it,
Yeah.
the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
There's nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's a currency note.
alphanumeric.
Yeah. But
Cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match when was this bond.
I think Mr. Bhushan should hold his peace for a minute.
Fourth, what is the information that you see when you scan the alphanumeric?
Malad, you see a number.
The details of the purchaser and the bank which issued the bond when you scan the bond?
No, Malad. That's what I'm saying. That correlation was not kept. For the reason, it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done, their bank account details, etc., everything is done. That is silo 1, if one may so call it, which is nothing near Orchard. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes. It finds its way in the. We next get to see the bond when somebody comes and says.
Mr. Salve, assuming that you construed our order based on the interim order merged with the final judgment of our court.
Malad, even in the final judgment.
Say that we will interpret our final directions in the light of the interim order, which has merged with the final judgment.
Malad, your lordships.
All details.
That's why we came to my.
Mr. Salve, we'll clarify to put it beyond any.
No problem. No problem at all.
We'll say that now SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed any, you will not withhold any details in regard to this within the purview of clause B and C of para 221.
Correct. I don't think there's anything else which remains. But
you have to disclose all details. Let there be no, because the burden should not lie upon the court or the petitioners who say, but this one has not been disclosed. But now this has not been disclosed.
Now we'll disclose it, Malad, whatever.
We must have finality to it.
Yes, we'll do it, Malad. There's no problem.
One more
Malad,
thing.
I have 2 minutes, Malad, if your lordship permits.
Yeah.
At the outset, Malad, on behalf of the central government, I completely disassociate myself with what Dr. Agrawala has written. It is completely unwarranted and ill-advised. I want that to be made very clear, Malad, on behalf of the central government. Now, Malad, I have something to share, and I have been watching this very painfully, Malad, outside the court. Malad, your lordships sit in kind of a silos. The lordships are, Malad, in an ivory tower, not, Malad, in a negative sense of the term. But what we know here, Malad, your lordships never come to know. The way in which your lordship's judgment is playing out, my lord, something your lordships must, my lord, be informed as highest court of the country. But what has happened? My lord, our case was that we want to curb the black money. A criminal may have paid the donation, but ultimately the donation comes in the white economy and we could not persuade your lordships. My lord, your lordships passed a judgment. Lord, every one of us understood the judgment and the directions in a particular way, that what your lordship wants is not, my lord, kind of a witch hunting. Earlier, my lord, our case was that witch hunting would be by the political parties. If A party is given, B party in some other state might victimize the donor. Now, my lord, the witch hunting has started, my lord, at some other level, my lord, not at the governmental level. The application comes of the SBI before your lordships on 11th of this month, my lord. and your lordships also, my lord, that's how, my lord, we understood, clarified the position. But most serious things, my lord, start happening thereafter. Lord, those before the court started giving press interviews, deliberately embarrassing the courts, my lord, and there is, my lord, a non-level playing field, my lord. On this side, nobody can rebut that. Neither government can do, nor state bank can do, nobody else can do. Thereafter, my lord, a series, a barrage of social media posts, my lord, at least intended to cause embarrassment, started during these 2 days. And thereafter, my lord, now it's anybody's field. It's an open field. My lord, statistics, your lordships are aware, can be twisted in any manner the person wants. It's a matter of, my lord, intelligence of the reader to understand. Now, my lord, based upon the twisted and other statistics, my lord, any kind of my lord, posts are being made. I know, my lord, your lordships cannot control that. The question is, would your lordships, my lord, consider issuing a direction which has a necessary and inevitable fallout, which the court would not be able to control? Lord, that saying Mr. Rohgi gave this money to this, then they have their own conclusion.
Mr. Solicitor, we are only concerned about enforcing the directions which we issued in clauses B and C of para 221.
That's
As judges, we decide according to the Constitution.
correct, my lord.
We are governed by the rule of law. We are also the subject matter of comment in the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm not, my lord, for a
Our
second saying.
court has an institutional role to play in a polity which is governed by the Constitution and the rule of law. That's the only job.
Lord, my purpose is to inform your lordships that there is something else playing out which neither your lordships intended nor the scheme intended. And, my lord, kindly bear that fact in mind. On 11th of March, my lord, we thought that we are ad idem, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My lord, thereafter this started in a very systemic.
All right. What order?
One fact.
Can I assist you? Not
No, Mr. Radgi, we don't need assistance right now at the conclusion of the matter.
One fact. One fact.
I am the person who's going to.
Lord, they have no stakes in the matter.
Forget my application.
No, Mr. Radgi, we'll not hear you when your application. We have to follow procedure in the court. It's a constitutional court.
One will allow
Yes,
us.
Mr. Radgi,
say
no,
something.
Mr. Radgi. I told you the reason for it. We are now at a stage when the
I am
judgment
not
is
on my
over.
application, not that it has become infectious. I am
Mr.
now
Radgi.
only saying
No,
that
Mr. Radgi, we don't need any assistance at all. We are clear. We had very able assistance on both sides. We don't need any third party assistance.
Election Commission has put out the sealed covers, but that's very interesting that those sealed covers show that some of the smaller parties have disclosed the donors.
We don't have to go into
No,
all
but
that,
because-
Mr. That's not our remit at all.
No, I
Yes,
understand.
what has happened after the judgment is not something we are concerned
Not
with
after
at
the
all.
judgment. What I'm saying,
Now-
no, what I'm saying is this, that since the order of the,
Very recently, I was asked about a critique on a judgment. I need not mention which judgment. And I said that, look, it's no part of the role of a judge, least of all of a constitutional court or even a civil judge, to defend their views. Once we declare a judgment, it becomes public property. It's the property of the nation. It's the property of the nation. And
no, I was only saying that your lordship's interim order of April 2019 asked the political parties to disclose the name of the donor. The information given by the political parties to the Election Commission, only a few of the political parties, the smaller regional political parties, some of them have
He
disclosed.
is not
the names of
addressing
the
your
donors.
lordships, he is addressing somewhere else.
The-
Kindly hear him for some time.
Correct.
So that it comes,
It's
my lord, in the
amazing.
newspaper
Amazing.
tomorrow, that
The-
Mr. Prashant Bhushan
Amazing.
vehemently said this.
Amazing.
That's the purpose.
Solicitor,
Pointing out
unfortunately,
something-
public interest litigation have now become publicity interest litigation.
It is
Absolutely.
publicity interest litigation.
I
It
am
is, my lord,
pointing
there
out-
are some hidden agendas. There
Something,
is no doubt, my lord, and I am not, my lord, apologetic in saying.
I am astonished.
And my lord, that is the matter of greatest concern, because judgments given, my lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately,
Lordships in your Lordship's Majesty
So what
would
I
not
was
know
pointing
what,
out-
what are the hidden agendas
You
behind
just
it.
dictate a short order. I
I
think,
just
we
point
are
out that
unnecessarily expanding upon the remit.
because the major political parties have not disclosed the donor.
Just give us 2 minutes to dictate the order.
Therefore, what all that I am requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a situation.
1 second, we got the point. You filed an application on that. In our order.
They have filed an
Just, Mr. Ansari, just 1 moment. Just do it in a very cool and calm atmosphere. It's a constitutional adjudication.
Yes,
Why should we, in our interim order, we said that the disclosure shall be made with effect from the date of the interim order.
Yes.
12th of April 2019.
Yes.
Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explain why we took that date. We said after that date, of course, the Constitution Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media, some via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rodgi. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the judgment.
the only reason why I'm saying
can't
that-
modify that date.
No, the only reason, because your lordship asked the political parties to give donor details to the election commission prior to that interim order. And while some of the political parties have given donor details, other political parties have not given donor details. The major political parties have not given donor details. And one political party, which is in power in one of the states, says, if somebody came and left it under our door, 10 crores of electoral bonds was left under our door, we don't know who it was. So therefore I am saying that because this is leading to a situation, though your lordship asked the political parties to disclose donor details by that interim order, only some political
Mr.
parties.
Bhushan, we have understood that argument, but what we are directing was the numbers are given, it will sort out a lot of problems. A lot of your issues will
But
get
for
solved.
Mr. Harish Salve, Learned Senior Counsel, states that there is no reservation on the part of SBI in disclosing all details which are in its possession and custody. Full stop. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date daldo.
could we have one more day, Thursday?
Stating, yes, that's certainly 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop.
Is to be given to the election commission.
In terms of the directions contained in paragraph 221.
your lordship may indicate the date when it will be uploaded by the election commission.
The election commission shall upload the details forthwith on the communication by SBI.